Hey everybody, welcome to another episode of the Clint Crowe Real Estate Show. Thrilled to be with you once again, and even more thrilled to have my friend all the way from the north side of Atlanta,
So far
Cheryl
away.
King, yes, also known as the Velvet Hammer. We won't tell that story today.
That is a throwback to an old radio show, right?
It is. Yeah, I always say that I call you the Velvet Hammer. People look at me like, what? It's an inside joke. It's fine. We go way back. So, how are you?
I am doing excellent. I traveled all the way down here to see the agents and, visit a little bit of Locust Grove.
Yeah, we appreciate you coming down. I always enjoy having you come down and teach classes here and imparting your knowledge. And I figured we'd reach out because I knew you hadn't had a lot going on lately. You hadn't been much happening, so you didn't have a lot to talk about. But
Nothing special, and I've just been making it up as I go along.
Yeah. I feel like there's been a lot of making it up as we go along. So, all right, obviously we're going to talk about what everybody's been talking about lately, and the topic that has been at the forefront of everybody's mind in the business, essentially, and that's the NAR settlement and kind of our response to it. So, what do you think about the changes? And we're not going to talk about, you and I've talked a little bit offline about the merits of the
actual case.
Of the actual case and
Yeah.
stuff. And that's, no matter what I think of it, or no matter what you think of it, essentially that part's behind us now.
Correct.
And so we're going to have to move forward. But the settlement, as far as the terms of that, give us a little bit about, your understanding and what the biggest impact you think it is for us here in Georgia.
Right.
And I think that we're a little different than a lot of other places. So
I agree, and I think, obviously the parts of it where, in order to work with, which is the key words, work with a buyer, you need to have an agreement. That I think I actually underestimated maybe the amount that was already happening as someone who's been around for 25 years and saw sort of, I didn't come in until 7 years after Bretta did. So I think I really thought everyone was doing buyer brokerage up until that point. I think the hardest part of this for in any state, including the state of Georgia, is removing a method of communication. And so I think that's really the part of it that has been the most disruptive and obviously, not solving any actual purpose. So
I think I had also assumed that the way we had done things with buyer brokerage agreements
Right.
or written and signed customer agreements, I really thought that was happening everywhere.
Yeah.
And I have lately found out that it was not. Our company, we cover a couple of different markets. And so I was at a meeting at an organization in a different market that we serve. And some of the questions, of course, obviously, a lot of that, because I was at the meeting, a lot of it gets directed towards me.
Right.
And whether or not there's a legislative response, a need for it. And we'll kind of get into touch on that maybe in a little bit. But they ask a lot of that because we're dealing with somewhat legalities in our Beretta laws. But some of the questions, I was like, yeah, it's already the law. Like we're already
That part's
supposed
not
to do
different.
that, right? This has not changed any of that. And I'm like, y'all have not been aware of what was actually supposed to be happening here. So.
The other part of that with the signing of the brokerage agreements and the timing and all of those other things, I think it's also there's no way, I think, for any individual broker to necessarily know, when it was getting signed in relation to when they started working with a customer, because there's no real mechanism by which you're submitting all of those things. You're usually seeing it when it's in combination with a binding agreement.
Yeah, and that's we try hard here to kind of handle that. We've got a mostly paperless system now with we use a program called BrokerMint for our back office stuff, and the agents do all their transactions in them, and they work together. So typically when the transaction's there, we'll be able to go in and actually see the documents
that have been created,
done, right? Yeah. As they're created, and they submit them for review and that sort of thing. Not always as promptly as we would like to. To your point, that's kind of the challenge, right?
Right.
And honestly, for a lot of agents don't even realize they think, oh, well, we get a contract, you got to send it to you. You get any brokerage agreement or anything like that signed, you need to send it to the broker, right? That's not, and they haven't been sending those listing agreements and those
Right.
buyer brokerage agreements to us. Listing agreements better than buyer brokerage agreements.
Well,
That's the
because
one we have the biggest
there are
problem
next
with.
actions, right? Like in
Yeah.
order to submit them for, so that anyone can find them, there are things that have to be done where on the buyer brokerage side, that's a little more amorphous. There's not any one thing until there's a contract that
Yeah.
you all are going to see on your end.
Yeah, so that was, before this even was, we weren't getting the buyer brokerage agreements as early in the process, and that's heretofore it wasn't as big a deal.
Right.
Now we're kind of re-examining everything
Well,
in our process.
it wasn't a big deal other than there were agents that were running the very real risk that they were going to be working and not getting paid.
Yeah.
And I don't know a lot of people who want to wake up every day and work and like keep their fingers crossed that there's going to be a paycheck at the end of it.
Not typically. Not typically. We had a lot of folks doing that, though. You're right. That's kind of, hope for the best, I guess.
I value my services more than that.
I do, and I'm glad you said that. That's been a conversation we've had around here quite a bit that I've had with the agents. And one thing I have really harped on through all of our discussions, and we've had multiple meetings in different classes on these changes and documents and the GAR forms and stuff that, one of the, I think, seems to be inconsequential changes, but I am a huge fan of, is changing terminology from commission to compensation for
Absolutely.
professional services. And I think for too long, we have not done a great job of presenting and standing by and insisting upon our value and what we provide. I think that most of our clients out there felt it, that they valued it, because otherwise they wouldn't have hired us. But then there were some that didn't really see the value, and a lot of it on the buyer brokerage side.
Right.
And I think this is an opportunity for us to say, look, this is what we do. This is why we do it. This is why it's important to you for us to do that and to really stand by that. And I think just that change in the discussion and in the forms, and it offers us an opportunity to present that in a different way than we had before.
And, we saw some of what happened in 2021 and 2022, where even with representation, buyers were having to give up a lot of their power and a lot of their rights, right?
Yep.
And there were agents that were greatly distressed about, I don't want you to do this without contingencies and protections and due diligence and inspections and all of those things. And that's my primary issue with what appears to be the goal of all of the litigation that is out there, is you're putting more and more buyers in a reasonable position that they're going to go without representation. And that is just a poor choice. And I say that as a person who bought a property last year. I have been a closing attorney for 25 years. I have been a realtor for, I think, 7 years here. I don't practice either law or real estate in the state of Louisiana, but I am fully versed in how to read a purchase and sale contract. And when we needed to buy a property in Louisiana, I hired a real estate agent. I hired a realtor.
Yeah. That's, we bought a building. Well, we bought this building last year. We also bought a building in Macon for our office down there. Our Macon agents actually was our agent. Right. I didn't know it. I had somebody that was down there, and she works in that market every day. I actually knew the property. Funny, she was the listing agent, had it listed when that owner had bought it, and the buyer's agent was now the listing agent, and she was the buyer's agent again. So
just changing positions.
She has some history with it and stuff, but that was important to me. I needed somebody that I don't operate in that market.
I don't know what I don't
day.
know.
Right. I don't list and sell actively anymore.
Right.
And I certainly don't do it down there every day like she does. And so it was important to me to make sure just to have the bases covered. It's like title insurance. Every property I have ever bought, and I've bought numerous of investment properties and stuff, and some of them I've had for less than a couple of months, as a rehab or something like that. I have gotten an owner's title policy on every single one of them.
Right.
And they're like, well, you're just throwing that money away. Yep. But not if I need it. That's it's almost like an insurance policy.
It is.
And I equate it to what we do and the need for us. And people said, oh, you think real estate agents are going to go away? I don't.
I hope not.
I hope not too. I don't think that I don't personally believe that we will, because I think there'll always be a market for what we do, because I think what people hire us for is too important. It's too much risk. there's too much now money involved with prices and stuff the way they are. It's their biggest investment, and they want and need somebody to help protect them to make sure that the things that could happen don't happen. And these contracts that we use they're really pointless if everybody does what they agree to do, right?
You don't need a contract if exactly.
You can do it on a handshake. It's there for when somebody decides to differ from what they had previously agreed upon, or not do what they had agreed to do. It's nice to have that insurance. I use the analogy. My degrees are in finance. I've had tons of training and classes and stuff in financial management, portfolio theory, all that kind of stuff. But all of our assets are managed by somebody else. I got a guy at Edward Jones.
Exactly.
And he does that because I know it, but it's not what I do for a living. And it's too important to put that for me to want to do an amateur level service myself. There's too much at risk.
Agreed.
And I think this is very much the same. So, well, good. I'm glad we agree on that.
That agents, the real estate agents and realtors in particular are important.
Yeah, I think so. And real estate attorneys. So the forms. I'm a huge fan of the forms, always have been. That is one of the things that really drove us when we started the company. And immediately, I'll be honest, we didn't join the Realtor Association. It's now 15 years ago when we started our own company. And it was at the height of the downturn,
I vaguely remember that time.
Yeah, the recession. They
that was
the
what,
Great
like
Recession.
09, 10?
Yeah, 09, November 2009. Yeah, in a couple months it'll be 15 years. And so I was like, what, I don't think I'm going to join right now. And what really drove me to was when they said, what, we're going to start charging for the forms because there's value.
Right.
And I agreed. I thought, well, if I'm going to,
if I'm going to pay that money for the forms, I may get the other stuff too.
Yeah, and then as I got more involved, and I had been involved before, but then as I really dug in and started to learn what the membership did, and especially on the governmental affairs side, and the things that they do to protect our industry and protect our ability to do what we do, and private property rights and home ownership in general, the advocacy work that's done by the Realtor Association and the training and just all of the things that's involved with it reinforced that idea. But initially it was the forms. I'm a big fan. I think they're underpriced, to be honest with you.
Probably.
I don't want to pay more or anything. Y'all don't give me any ideas. But, but I do think that they are of such high quality and they're updated regularly. And you've got folks like you and others who are you're on the forms committee. You've been on there for...
I participate with the forms committee. I'm on a number of the subcommittees.
Okay.
So.
Yeah. So, you and others are in the room. We've got attorneys who do this for a living every day.
Yeah, so 3 attorneys, but a lot of the people are your brokers.
Yeah.
It is, and there is a value to hearing from everybody what's going on in the different areas of Georgia, what they're seeing, what they're, Mitzi will tell you what's going on in St. Simons, and it's just you need to be hearing about those different areas.
Right, and that's the thing that I really like about the forms in the committee, and people get frustrated, like, oh, we got forms that change every year. I mean, usually they're twice a year.
Twice a year, actually.
Some mid-year revisions.
Some mid-years more big than others.
Yeah, but currently, we're speaking of that one we're in right now.
Yeah.
But that's the great thing about them is our business changes constantly.
Correct.
The things that we need to be aware of, the things that we need to have in place, and the conversations we need to be having, the protections we need to have in place for our clients, those change all the time. And we need to make sure our forms keep up with that. And that's a great way to do that. And to hear from other people in other areas, you get best practices.
Well, and the way those requests for changes are coming in are, first of all, the membership. Mm-hmm. So just whoever is sending things, through the helpline on the GAR website, reaching out to different people that are on the committee or attend the meetings, and then you've got legal things that are coming up. So a lot of that from Seth, obviously, and that includes lawsuits that have happened in the state and accommodating our forms to what the existing litigation has been. And I'm not talking about NAR compensation settlement. Right. I'm talking about lady slips in house during a showing, and what do we need to do about the forms because this lawsuit is happening. So, those things are a direct result of people paying attention.
Yeah, and one example that I always refer to on that, and I tell people about when this subject comes up, is the earnest money.
Right.
As full liquidated damages. It used to be that the buyer had a choice to either retain the earnest money, the
Seller.
the seller had a choice to retain their earnest money as full of liquidated damages or give it back and sue.
Yeah.
They don't have that anymore.
No.
And that was a direct result of a lawsuit and that case law that came about. We
that at least
changed our course of
questioned
action.
it, and I mean, and I hate the change, quite frankly.
Yeah, me too.
Because I'm whatever. I want as many remedies as humanly possible because I think it holds people into transactions.
Yeah.
The suit that it was based on was a lower court, not appealed, and not even in writing, so that's problematic. But it was the best reaction possible to something that is sitting out there as Georgia case law.
Yeah, and that's we don't know. Everybody asks me, well, what do you think will happen if they do this? And most of the time, my answer is, who knows? If you go to court, you're going to get a judge or a jury, and you're going to
who's
get
a human
decision.
being, and before lunch or after lunch may be a different result. So.
Yeah. I've been in front of a lot of judges, and
Have you?
Most of my previous career.
Okay.
Mostly in my previous career, I was a witness for the prosecution.
Okay.
But yeah, you never know.
Right.
You never know from one day to the next, or for, like you said, morning to afternoon, what the judge is going to decide, what they're going to think is important, and how they're going to interpret these different sets of facts.
Right.
They are the trier of facts, and how they decide to look at those and what they think is important, you never really know.
Right.
So we're doing the best we can based on the information we have. To that end, I think these changes on the forms trying to help us comply with the settlement, I think they're good.
Ish.
Yeah.
It's okay.
Yeah, it's good. It's a good start. I think it's a good start. I think it's a good start. I think that there's a lot of those changes are at least going to make it easier and help us figure out what conversations to have with our clients. If we go through and use those forms, it'll kind of help facilitate some of those conversations, I think. But I think there's some changes that we could probably make now that we've seen them in practice for just a little short while, that we're starting to see, hey, maybe this, and you alluded to some of that earlier in the class you just did. What do you think about those?
I think in terms of the three compensation confirmation documents, right? Not talking about the brokerage agreements. We're talking about the ones that are part of our agreement. So instruction of closing attorney, pre-show and compensation, and then the brokerage compensation exhibit. I think there's at least one too many. But I can also tell you that we were making these changes before the settlement really went into effect, and tried to get them out a month earlier than it actually happened, and couldn't because everyone was just still looking at them and still trying to figure it out. There's confidentiality within the committee, which is a good thing because people should be able to speak openly. But I can certainly tell you how I felt, which is I didn't foresee some of the things. I feel like there was going to be, how do we take what existed and go forward with the exact same system, but in a completely legally compliant way?
Right.
And I think that there is a certain segment of the population that probably feels that way too. But every change has unintended consequences.
Yeah.
And I'm not saying that those unintended consequences are necessarily negative. We just didn't see them coming.
Right.
And I also don't think that we had, because the settlement didn't go in effect until August, because as a practical matter, that only gives the forms committee 2 or 3 times to meet before January has to go into the hopper and be done. I think we will see some changes, but we may see a big mid-year revision next year too. I don't know. It's going to depend upon, sort of what the world looks like. But I can tell you that there are a whole lot of people that are focused on trying to help the realtors do this the correct way for themselves and for their clients. And it is exhausting sometimes to have been on that thing for 3 hours and just feel like you wound yourself into a circle. But you do it, and you go back and you do it again.
Yeah, that's, the whole goal of what we do is to protect our clients and serve our clients. And that's, the forms are there to help us do that. And it's a different world. I think, I thought, and I still kind of think, it's going to just sort of be business as usual. I think a lot of what we have done for as long as I can remember, as long as I've been in the business or been around the business, I think was done in a way that was determined by market factors and market forces,
right?
Free market forces. I think those are eventually going to work their way back to the forefront. I personally think that, you're still going to see the majority of sellers providing some sort of compensation just like they provide some sort of buyer closing costs
Right.
in most markets because
Because
of their
that's the
property.
most financially feasible way for a purchaser to buy a house.
Yeah.
Yeah.
And, and there's an argument to be made, and I have made this argument, that the seller is not actually paying anybody. The buyer's paying.
I haven't seen a seller come to closing with money since like 2013.
That's right. That's right. So technically, the buyer is the source of the
They are.
funds. They're paying it. It's just going through
Right.
the seller. So, it's somewhat semantics when it comes down to that. At the end of the day,
But it's also directly related to how we set up the financing structure and what can be
Yeah.
financed in and what cannot. So, without any changes there, which I don't necessarily think, nothing will happen with our government in the short term anyway. Let's be very, very honest.
That is a fact.
That is-
Speaking of, I'm glad you said that because that was a topic that came up at that meeting I was just referencing earlier. And we had this conversation, and you slightly alluded to it in the class earlier about there being some questions about the forms being done by the Realtor Association,
Right.
by a collection of brokers doing it, and it not being a state-provided
Right.
form. Somebody suggested at that meeting and asked me what I thought about us going to a state, since it's state laws, the Beretta laws, that
Right.
sort of thing, that the state should provide the forms. And here is my thoughts on that. The state doesn't provide traffic citations, which is kind of what needs to be on there, right?
Right.
We don't provide accident reports. We got to say what needs to be on there, family violence incident reports, that sort of thing.
Right.
What needs to be on there, we don't necessarily do it. The law says what has to happen and is codified, but we don't really create the form.
Well, and when
my concern with
Yeah.
it, my biggest concern is just what you said. We do things. Look, in Georgia, I think the legislature and the governor's office, executive branch, the judicial branch, I think we all do fantastic. I think we do better in Georgia than a lot of other places, and we're super responsive. We still don't work that fast.
No.
And to try to respond and have our forms change regularly, like what you said, and because most of our changes come from input from people on the ground who are seeing this and saying, this is what we need. These are the things we're seeing. This is what we need them to say. To try to then have that go through a legislative process for us to have to do that to change the forms, I mean,
No.
we don't always get it right either.
Well,
We say part of the reason we go back into session every year is to fix the stuff we screwed up the year before. And there's
the
some validity to that.
the state promulgated a power of attorney, which is excellent, right? There is a general financial power of attorney. It solves a whole bunch of things. It lists real estate as a way that you can use that power of attorney, and it does not meet the title standards of the state of Georgia. So, because those aren't state laws, that's title standards that our title companies have. They're not close enough to the ground
Right.
to see that one basic item, which is you can't use it for the purpose that is the first checkbox option on there. And what do you think everyone thinks that pulls a Georgia state promulgated power of attorney and checks off real estate with it? They would assume they can sell real estate with it. So no, I don't want to give them all of our forms and have them head in that direction. What I also don't want to see is every brokerage coming out with their own forms either. And that is the alternative option to how this could work. And we have a relationship with a company in the state of Alabama, and they were asking me about coming and doing some teaching there. I'm like, well, there's going to be a little bit of a learning curve since the only thing I know is I hate your football teams.
Yeah, I didn't ask earlier how you were feeling after Sunday
Vegas
night.
was very fun.
Yeah.
Not so much the football game, but it's okay.
Those watching at home probably may not be aware that you're an LSU fan.
I think they probably figured it out at some point, right? But yes.
Yeah.
So I didn't wear any
Alabama,
purple Tiger, but we can all agree that not huge Auburn or Alabama fans, right?
I did notice your watch band earlier. Though.
Oh yeah, I had to have a waterproof band for the pool at the casino, right? So yeah, a little purple and gold going on. But when I was asking about, okay, I'll give it a shot. And there's some things like code of ethics and some of those things and negotiation that it's going to be fairly, borderless. And so I said, can you send me, the standard forms for the state of Alabama? There aren't any. I mean, and that is terrifying to me because I spend every month of every year trying to help realtors use realtor forms in the best way possible, and realizing that there are options and nuances and strategies and all of those other things. And there are levels of understanding of our forms, right? There are people that can do absolutely the minimum that needs to be done, and then there are people that are using them at a whole other level as negotiating tools, and there are people in between. But how do you, like, as a non-lawyer, how do you represent clients and have 20 different versions of a purchase and sale agreement and explain to them or help them work their way through it? I think that's the practice of law. I got to be really honest.
I do too. I think you're going to need to have an attorney craft your forms first of all. And then you're going to need to hire an attorney to explain those.
And they probably have it on the crafting side, right? Like, it's good for the lawyers, because 20 lawyers, at least 20 lawyers got paid. Right. Or one lawyer got paid 20 times to that's the better model. Exactly. But the whole, like, explaining it and trying to figure out what the meaning of it is and be aware of that many different versions of them. I think that goes beyond what a real estate agent can or should be expected to do.
Yeah, I think so too. Look, I am fully 100% team GAR
forms.
Yeah, team GAR forms, man. I just, because I know them, and I think, and I've been in some of those rooms. I've not ever been on the forms committee, but I've been around and, had some of those discussions, and I've used them so long, I know them so well, and I know how well thought out they are. There's a book.
A whole book.
Just a whole book. The Red Book of Real Estate Contracts in Georgia. I got the newest version now. It's actually two different books for it now.
2 volumes?
2 volumes now, and Seth had to make another volume. That can help you answer the questions about these forms and stuff. And it's just such a resource and such a valuable tool for us to be able to provide for our clients.
Correct.
For years, man, in my first place I worked at, the broker was there, has been around forever and ever and ever. Learned a lot from him, some of it by learning what to do and some of it learning what not to do. I still love the guy. We're still friends. But, he was always, he was complaining when the listing agreement went from 2 pages to 4 pages, and I'm like, now it's like 8 pages. And so, but it's because the business changed. The risks to our clients have changed. Things are more litigious now. It's kind of the world.
Well, and I think a lot of what we've added and done are actually, we're sitting in a buyer beware state, right?
Yep.
So, but we've created disclosures, we've created contingencies, and we've done all of those things. And having been doing it our way for a quarter of a century, the first thing that I wanted to do when we were buying property in Louisiana is look at a Louisiana purchase and sale agreement, because I think I saw one maybe 15 years ago answering a question for somebody, but that's been it. You're right, it is shorter. It's fine, like it's only like 4 pages long. That includes all financing contingencies, all everything. And I will also tell you, for a deal that got really complicated and went sideways at the last moment because of condos and insurance and all the things that happened, I will also tell you that all of my contingencies and all of my outs lasted all the way to the closing. And so as we were working through this and I was trying to figure out, like, how are we going to go? I can't see any way my earnest money was ever at risk for anything. Yeah. And that felt, as someone who I'm buying it, that feels great in the moment as things I don't have control over are going sideways. But as a seller of property, to go all the way to the table without having any confirmation, that this is going to close, or any compensation for the how many ever weeks that you took your property off the market, dude, that's not okay.
Yeah.
And a lot of what we've done have protected buyers, but also given sellers, okay, like, buyer's going to have a certain amount of time and then to do a whole bunch of stuff, and we're going to ask them to do all these things and verify all these things. But after that, the seller's either going to get a closing or some money.
Yeah, and I think that's, over the years, they've either been weighted more heavily towards the buyer or the seller.
Right.
And I think now we've gotten to a pretty good area to where they're pretty fair for both, right?
I think we've gone through seller markets and buyer markets and made adjustments all the way through. And then I do think that there is a real impetus and push and move to balance the equities.
Yeah.
We want to make sure everyone knows what their rights are and everyone has some.
Yeah, it's not too beneficial to one side or the other. It's
No,
fair,
it's not
right?
like a new construction contract where this thing is, for very understandable reasons,
Yeah.
this thing is going to be very weighted to the seller. No, I don't think the GAR forms are like that at all.
Yeah, I think they're very reasonable. I think they give you the opportunity to do what you said you're going to do, right? To make
Right.
this agreement gives you a short time to find out, hey, am I getting what I'm expecting to get? Am I able to come up with the funding I'm supposed to be able to? They give you a reasonable amount of time for that, but it don't have the seller waiting and moving their stuff out of the house
Correct.
for a closing that's never going to happen. So
Yeah.
I think I think that y'all have done a great job with those, but. Yeah, back to the three forms, basically.
The compensation
the
forms.
compensation forms. I think you're right. I think they're one too many. Probably, maybe two too many. I think
certainly one too many.
There's one that I don't think that we're probably going to see used a lot, because just from what I'm seeing now, I haven't figured out a way feasibly for our agents to really use them.
Would that be the 258?
It would be the 258. Yeah. Just, initially I think a lot of them were, I had agents asking me, they said, do I have to fill one of these out and
Right.
send it to every listing agent for every property I want to show? And I'm like, maybe, if that's,
We'll see.
If that's what you want to do to be assured, you can have a conversation with them on the phone. Depends on whether you trust them or not. That's,
Right.
that's what
It also
you're
depends
really
on how
risking.
quickly are you making an offer. What are you going to include at that point? There's a whole timing thing, and I think with for those who don't just memorize form numbers for fun, the 258 is the pre-showing compensation. So it
Yeah,
really,
sorry, I didn't-
you and I were on the same page.
Yeah.
But I think that really was the one that was anticipated to provide in a legally compliant way an offer of compensation that can be relied upon.
Yeah.
The problem is when you take away any central, easy, transparent way of communicating information, then what you have is a document and then a haphazard free-for-all surrounding it. And I think you're correct that that's probably the one that we may see least used.
Yeah, even on and I liked your example. It would be great, and if I was a listing agent, I would like to think that I would have that maybe done up and
Right.
kept somewhere handy where if somebody asked, I could shoot it to them, pretty quick, or
Yeah.
shoot them a link to a Dropbox or something like that. And that's, with our system, we can upload it in the transaction, easily email or text the form out. It's not super hard, but not everybody's going to do that. And then it's still, you got to have the conversation with somebody to find out, like,
Got to get a response.
you got to get a response, right? Yeah, you got to figure out how you're going to disseminate that form
Correct.
to them, because you're right. There's not a central repository
Yeah.
for them. I think it's just going to make us have conversations. The other one, I think the one you're probably going to see, the one I'm seeing used the most is the F-259, and that is the
Broker
the
compensation.
broker compensation exhibit that's submitted with an offer. That's kind of what I'm seeing used more now. I've had people ask me about the instructions to closing attorney, and I think it's great, but you've got to do all the stuff, and it's not. There's no guarantee.
So here's
Because the seller is not, it's.
it is. I think what people do need to understand. I think once it's fully signed by everybody, that's fine. But it
Yeah.
hasn't been the process to do those at the beginning of the transaction.
Right.
In fact, we've been begging real estate agents for instructions to closing attorney for 15 years now, so we could finalize a settlement statement. It was your paycheck, by the way.
You would think.
I would think that they would be just Johnny on the spot.
That's what I tell people all the time. I'm like, why would you not do this? Like, this is the one that ensures that you get the compensation you're due for the professional services you have provided.
There is at least one closing attorney, and you all have to realize that as your real estate agents trying to go through this, that I'm on the calls. I did training with the Thomas and Brown, with the attorneys, the closers, and the pre-closers for them. Obviously, Seth and Catherine are both on all of these forums calls. I am quite sure that they're having these conversations with their staff. That's two law firms in the entire state of Georgia. Everyone else is just kind of reading it and trying to make a reasonable legal determination.
Yeah.
I don't think theirs is as good as mine. I got to be really honest, and I've never had a problem with self-confidence confidence, but I feel like I've got a pretty good basis for that.
Yeah.
But there was at least one that was saying you have to do instructions to closing attorney for everything. And my problem with that is that if there is inconsistency, if you're doing multiple forms and you're double dipping on some information and not on others, I am concerned. Yeah. I think that one form would be better, but I think a lot of it has to be driven initially from the seller side of the transaction, because the buyer doesn't know who the payor is for things. So the listing agent needs to be the one who's originally creating these. But I do think that the broker compensation, it is one step off of putting the commission back into the agreement, which is where it was 20 years ago.
You're right. We may wind up, I don't know if we'll ever see it go back into the actual document. I think it'll probably stay as an exhibit, though. I think that's where we're going to wind up.
Yeah.
And the instructions to closing attorney, like, it's great, but you've got to have the conversation. You got to get it filled out. You got to get it signed. Then it matches the brokerage agreement and stuff. Then it's good. But people aren't having those conversations up front, and they're wanting to make sure before they get into contract they've got some sort of written documentation of that. That's where I think the F-259, the exhibit.
Yeah, because the instructions to closing attorney is just a completely separate form that is not actually a. And people have asked about making the instructions to closing attorney an exhibit to the contract. We already have an exhibit to the contract, and I really don't think that non-lawyers should be trying to make things into exhibits. I think you should, for the most part, use the forms as they were intended to be used, and don't use documents that were never intended to be an exhibit, and don't have some legal language in it, an exhibit to an actual contract. I have had problems with people, saying the legal description is attached, and then, attaching one page that says exhibit, B or whatever the legal description is, that's the legal description, and then they include 9 other pieces of paper right behind that. I don't know whether that's part of my legal description. It's white noise as far as I'm concerned. Yeah. So I think we need to be really careful. Non-lawyers need to be careful trying to create exhibits.
Yeah. No, you're 100%
not
right.
wrong.
No, you're not wrong. That's when I teach classes to the agents, and we do classes about the contracts, or I have did a lunch and learn just recently down in Macon on the and kind of a deep dive into the purchase and sale agreement too. Just not as it relates to the settlement questions and things, just here's the things that you're going to run into, and here's the parts you need to know that are most likely to come up as an issue, and how you'd be better serving your client to know the answers to these. And I tell them all the time, the worst part of that contract to me, of the purchase and sale agreement, any of the purchase and sale agreements, land, regular lot, commercial, whatever it is the special stipulations, big old blank. And I tell them, you're going to see this big blank, and you're going to feel like you have to put something in there. Because you're like, I'm not going to feel like I'm earning my compensation if I leave this blank. If I put a big old NA in there and don't put something in it, they're not going to feel like I'm doing my job. So I've got to put something in there. And then the problem is, when we decide to put something in there, we write stuff that makes the contract completely void.
Correct. Or just override something that we didn't need to override. My favorite were the financing contingencies with appraisal language, and then you write completely separate appraisal language as a stipulation. Yeah. It's going to override the contract. It's going to override the exhibits. And I'm like, you don't even know what you did at that point. Yeah. So, and that leads to the compensation stips that we have out there as well. I mean, they are still there. And I will tell you that in the broker compensation, a relationship and compensation section of the contract, in the B section where all the important information is.
No, you mean the B section that nobody ever reads.
The blah, blah, blah.
Yeah, blah, blah, blah. That's it. Blah, blah, blah.
They just yada, yada, yada their way totally through that.
Yeah, B and C have some important stuff.
They really do.
They really do.
But part of that is acknowledging that the agents are not parties to these contracts, yes. Right? The buyer and the seller are the parties to the contracts, and also in the C section is where it says that. Yeah. And so, it says that the agents are signing these contracts to acknowledge their position as a broker and, if applicable, as the holder of earnest money. We did put information in the compensation section that the agents are beneficiaries, basically, of any compensation stipulations or exhibits or anything else, and that can't be changed without their consent. But I will say Seth has recommended recommended, like, use the exhibits, use the documents. We do still have the 2 steps that are out there. Now, one is the VA one, which is kind of, as of August 10th, at least for right now, there is an allowance for veterans to pay compensation. And so, I don't know, but the recommendation is to not use the steps. The recommendation is to use the forms and just kind of get comfortable with using them.
Yeah, that's always been my advice. Use the exhibits. If you can't find an exhibit that covers what you need, look in the pre-done steps that are included as part of the forms.
Exactly.
And if you can't do that, call your favorite closing attorney.
Correct.
Somebody, and ask them or call me.
Yeah.
And I'll call one of them. It's just, you got to be so careful because they're trying to cover all their bases. They include so much subjectivity in it that you lose your mutuality.
Well, they'll also
repeat
repeat things that are still there, but they write it slightly differently. And it's like, well, why did you write that? Was that supposed to change something, or are you just repeating yourself but ad-libbing a little bit?
Yeah, the part that, when Howell used to teach these classes eons ago, and he always would say the $10 clause, basically, and everybody's like, what does that mean? Where's the $10? They don't understand. Anytime they add something that just makes it an option for the buyer,
right,
to walk away, or the seller for that matter, but more often than not, the buyer.
The legal technicalities, right?
is now it's not a binding agreement. You don't have a meeting of the minds. There's not mutual consideration.
Right.
That $10, the receipt and sufficiency of which is hereby acknowledged.
Yes.
Even if you say, well, they didn't give them $10. You said they did, so it says it. So
I had a blank amendment to agreement. So on the blank amendment to agreement, we automatically put that consideration language in there, right? Because the amendment, contracts are mutual. They're mutual promises, mutual rights. And so those are, and there is consideration language in like the due diligence part and other things. But in the blank amendment to agreement, we don't know what people are going to write on this.
Yeah.
So my favorite one that I got, and I have reused it in the classes, is the due diligence period is extended to whatever, right? Giving the buyer more days to be out. Very unilateral. The $10 is hereby removed.
It's perfect.
I'm like, so I use this as an example of if you don't understand why it was there, don't take it out.
Yeah, that's it. That's
phone
perfect.
a friend.
That's perfect. Yeah, that's that would be.
Yeah,
that's poor.
That's
somebody's going to be disappointed if this thing doesn't close.
You
actually multiple people are going to be disappointed if this thing didn't close because. And
at least one real estate agent is probably going to see at least a GREC complaint, right?
Yeah.
Which will take a year or two or $1 million to actually be heard, but whatever.
So many times. They get these things to close on void or voidable contracts that because everybody followed through, it didn't matter.
No one was trying to get out.
But it does matter. It doesn't matter till it does matter, right? For those folks that do that, if this thing don't close and, the seller's like, well, they're in default. Well, default of what?
Exactly.
There was no contract. You had no binding contract.
This is August, so it was the back to basic. Well, it was August, right? I've lost track of time when I hit.
Is it? Oh, it is September.
Mountain time zone.
Yeah.
But I was doing the in-depth contract, which is what I did today. The back to basics, back to school, and I've had more than one agent walk up to me and say, "I made so many of those mistakes." I'm like, "Yeah, but now there were mistakes, and you didn't have to have them blow up in your face,
right,
to figure it out."
Right. Fortunately, this education was not near as expensive as it could have been.
Exactly.
We've been in it long enough. We've had a few of those very expensive seminars that we learn from, and me included. Like nobody is. There's going to be times that you're gonna you're gonna make a boo boo.
We are humans.
We are humans. So there's so much uncertainty.
Right.
But I think at the end of the day, like I said, I think we're going to wind up getting back to business somewhat as normal. It'll be a little bit different, but I think that there's going to be a need for what we do. I think we're going to continue to be able to do what we do. I think there's going to be a market for what we do. There's just some different conversations that we need to have. And the one thing that I do tell all our folks, is that Georgia, we are in such a better place than some of these folks in other states. Like, it's a big change for us. Like,
Right.
there's a lot of questions and a lot of uncertainty. But
It's some
think about
compensation
states-
discussions and some negotiation discussions that maybe not have been quite as fleshed out, right,
Yeah.
in the past, but they were at least there.
There were some assumptions based on things that were
Correct.
in the MLS. You didn't have to actually talk to somebody. You could just look and say, oh, well, this is what my compensation is going to be. That
Right.
was covered. Now you actually have to talk to people and
Yeah.
have a conversation at some point, right? And make sure you're on the same page with that. You've got to have more conversations with your buyer or seller client about,
Offer
why this is there
options
and what the options are, why it would behoove them to do one or the other,
Right.
What options, why this would be better than
Why
that
we
one.
should structure it one way as opposed to, yeah.
Right. And the benefits to that and drawbacks, the pluses and minuses, because there's pluses and minuses to both. They can certainly, they don't have to offer buyer compensation. If it was me and I was counseling a seller, I would say, I think you should, because that gives you the largest available pool of buyers,
Right.
which is going to help your property sell faster and for a higher price.
Yeah.
Historically, that's the way it works, right?
Yeah.
The bigger pool of buyers you got, the more likely you are to sell it faster and for a
Well,
better
and you can
price.
do a mathematical example where you include it one way, you don't include it the other, and a buyer can buy it built within it, and they can't buy it without it, and the seller nets the same amount of money in either case.
Yeah.
So, yeah.
And the other point that I have been making, and you're the only other person that I have heard say this.
So it must be brilliant, right?
It must be. It really, when you said this, I was like, I am smart. Golly, yes, it's fantastic. Like, I said the same thing. Nah, but it's the part about the compensation, being baked into these prices already.
Oh yeah, that the sellers need to understand that everything that you're looking at where properties sold historically had the compensation built within it.
Yeah.
And so, if there is not that compensation built within it, yeah.
Yeah, and you look at an appraisal, they take off seller concessions off the price, right? Seller concessions were in the MLSs forever for that purpose. So
Right.
you could use that to
say why did they, because if you have one that has a huge allowance, like let's not just say it's money, let's say it's a huge flooring allowance or something else that's in there. Well, they could have sold that house for $10,000 less, or they gave them $10,000, so the house is legitimately worth $10,000 less, all things being equal.
Yeah, so when we price property based on comparable properties.
Right.
And so, I think that needs to be taken into consideration. When if I were talking to a seller, I would say, if you want the same price based on these comps of where it came out at, understand.
This is
these
how much
prices
money they gave up as part of that.
These prices include buyer compensation. And so if you don't want to offer that, then we need to lower your price, because you're not going to comp out the same as these. And so I was very excited to hear you say that, because I had been saying that that's the price is already in there. That's where the prices are. It's already in. But I think that we're so much better off than some other states that did not have buyer agency. I was in California in June.
I'm sorry.
Yeah, well, it was I wouldn't say a free trip. I had to pay for the flight. It was a Century 21 Owners Conference.
Okay.
And it was actually the week of my birthday, and we were in Sonoma up in wine country.
So it didn't suck.
No, we actually went, my wife and I went we did a bike tour of some wineries and stuff on my birthday. So it's kind of groovy and beautiful country up there. I was talking to brokers from all over, and we had some conversations, and they were just flipped out. They had no idea. They had never even considered a buyer brokerage agreement or any of that, and it was like a new world for them. Like, this is completely upside down, and we don't have that.
No.
And I'm thankful that somebody way before I was involved. I didn't get into business till early 2000s, so that was 93 when it. Okay, maybe he's got signed into law in 94.
94, I think so, yeah.
And so that was well before I was in the real estate business, and very well before I was in the legislature. But somebody had the foresight, right, to do that here. And so the conversations we're having are fairly benign compared to some of the conversations and some of the changes people in other states are going through.
Yeah, Seth said, I think it was at 400 North. First of all, I read a law review article about Breda when it first came out, which I thought was really good. And that said that there had been some discussions in other states of, having it be a model, actually, model legislation. And I think we're at 400 North toward the beginning of July, and he honestly feels, and I tend to agree with him, and I don't always agree with him, but he said that if more of the states had adopted actual buyer brokerage, because you can argue whether cooperative compensation or baking it into the purchase prices and all of that are a good idea or a bad idea, and unless you want to change what financing looks like, I think that is a very good idea, and I think logistically it's the best way to go for all of this. But if we had more states that had adopted buyer brokerage and we had more real agreements with clients, and so that buyer clients knew what their rights were, what their protections were, and how the compensation worked, that there even was compensation. Because if you'd ask most buyers, did your agent get paid? And they're like, I guess they did. We don't know how, whatever. I think if there had been more states with real buyer brokerage, not just whatever the 16 or 18 or how many ever there were, I think there is at least a decent chance that we wouldn't have had the lawsuit.
Yeah. Buyer representation is important. And another point you made that also, this is the second time I felt smart because you said something else.
It's not the second time you've ever felt smart, Clint.
Well, it's the second time I've had any kind of validation.
You don't have self-confidence issues either.
It's the second time I've had it validated by somebody else, right? That I knew was smart and said the same thing I'd said. No, but it was about the fact that transactions are smoother. I have said, I would much rather have, I've been doing this long enough that I was doing it, and especially in the market we were in, down when we were doing a lot of lake property and stuff, and it was a very niche market. Dual agency was a real thing like that. It's not so much anymore. But then I've been in a
and it probably isn't that much anymore because there has been more buyer representation. Because I saw more, Sally owns the neighborhood and she's going to take both sides at each one. And I grew up as an attorney getting Sally's butt out of the fire in dual agency situations. But I think as we got more comfortable with establishing buyer brokerage, I think the natural result was less dual agency.
Having worked as a dual agent and thinking, I want to get a double ender on this, I want both sides and all that. After a while, when we started having more buyer representation and not having to do that, it's a lot easier. The transactions are smoother.
Right.
Because you can say, well, if you're representing the seller and working with the buyer, even if you're working with them as a customer or representing them as a client, either one, well, that's twice as much work. It's really not. I think it's more than twice the work.
I think it is, too. It's the opposite of synergy.
You're representing one and the other, so you got to deal with this one, and then you've got to also handle the interaction.
Correct.
It's like saying, I got 2 kids, it's twice as much work. No, it's really more than that because you've got the one kid, the second kid, but then you've got to deal with the issues that come up with the interactions of those 2 kids.
Right.
So
and the context of where I was saying that was, there are different ways to pay compensation, and I could pay all of it to my listing agent and have, the seller's broker and have the seller's broker share out, or I could pay it directly. As a seller, and I think as the most consumer-friendly way to do it, I think that if I'm going to agree as a seller to pay compensation, I would want to pay each side. But I at the same time said, if an unrepresented buyer walks in, I would have a real, I would hope my agent would have a real conversation with me about the benefits to me if we get an agent, another agent within the brokerage, someone to represent them, the actual benefits, financial, time, actually closing, all of those things to me would be worth it for me to say, yes, go get them an agent. And I understand that means I'm creating compensation obligations at the same time.
Yeah. And again, I think it goes back to having those conversations with our seller client in that case and explaining to them why it's so important and why it makes a difference. The transactions are smoother.
They actually close.
They actually close.
They're not almost home?
No, not quite. Yeah, another inside conversation. That's
right.
I ran across a company named Almost Home, and I thought that's not quite what I would have come up with, but okay. It's
you do you.
Yeah, almost there. Nearly made it. Well, I don't think we have nearly made it. I think we have fully made it.
Yeah, I think so.
To the end of our conversation. I appreciate you coming and doing this. I also appreciate you coming down and always been willing to come down and do these classes for us. You've got such a wealth of knowledge and experience with this, and you know the forms so well, and you're able to put them in a context that I think our agents really buy into, and,
Right.
and they can really relate to it. It makes an impact for them. It makes it memorable for them because it's in a way that matters to them, that they can see why. It's not just enough to teach somebody something. You also need to help them understand why they need to know it. And I think that is...
And I think we do.
You know.
I do a lot of trying to say, I'm your seller, or I'm your buyer, or I'm your whatever, or you're the. Think about how it would feel to be, or think about what your concerns are. I don't do as many closings as I used to do because I'm teaching a lot, but I talk to a lot of brokers.
Yeah.
I provide support to a lot of brokers, emotional and otherwise.
Yeah.
And I talk to a lot of agents. I mean, between the class and this time, I was answering a brokerage question for an agent, and I do that for our pre-closers and our closers and our attorneys. And I think there's a certain value to getting to look at stuff because, and I remember what it was like to be a buyer twice and a seller once. And I will say both of those transactions, I guess with Louisiana property, a buyer 3 times, right? None of those transactions were without its struggles.
Yeah.
And I remember every moment of how it felt to be in my 20s buying the first one. I remember how it felt to try and sell and buy during an economic downturn that was '08.
Yeah.
I remember all of that, and that informs my thoughts on the forms and also how I should be helping the agents work through them.
Yeah. Well, like I said, we appreciate it. It's not a short drive.
No, it is not.
So I'm always appreciative of you coming down. We always try to look after you, at least while you're here, feed you good.
Exactly.
And make sure you're taken care of. But we'll be in Destin next week for
We
the
will
NAR
be.
conference, so I look forward to seeing you then. And maybe next year you can come back and we'll check in and see how things are going and kind of where... I've had a couple of guests that said, we'll do a check-in next year and see how things are feeling.
Exactly.
I think next year we'll be feeling better.
I think so. I really do.
Yeah. Well, thank you again for being here. And thank y'all for watching. Appreciate you checking in. And we'll look forward to seeing you next time. Take care.